This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
All right, welcome. If you're prepping for the SQE1, today we're going to tackle one of its most complex corners, claims for psychiatric injury, or what the law used to call nervous shock. So let's get into it.
Here's our game plan. First, we'll get our heads around the big problem the courts are always worried about, the fear of opening the floodgates. Then, we'll map out the 3 types of victims the law recognizes. We're going to spend a good chunk of our time on the hardest one, the secondary victim test, and that includes a massive update from 2024. After that, a quick look at the rarer involuntary participant, a chance to test your knowledge, and we'll wrap up with a revision checklist to make sure it all sticks.
So, to really understand why the rules here are so, tricky, you first have to understand the one big fear that has shaped this area of law for over 100 years. What is it that makes the courts so hesitant when it comes to harm that's purely psychiatric?
Just take a second and think about this scenario. You see something awful happen to someone you love. The psychological trauma is completely real, but you yourself weren't physically touched. So, should the law be able to compensate you for that? This is the exact puzzle the courts have been wrestling with for decades.
And this is the core reason the law is so strict, the floodgate principle. It's this deep-seated judicial fear that if they make it too easy to claim for purely mental harm, they will unleash a tidal wave of lawsuits they just can't manage. And to stop that from happening, they've built a whole series of legal barriers or control mechanisms that a claimant has to climb over. So, right off the bat, here's the first hurdle, and it's a big one. The law draws a very clear line in the sand. On one side, you have things like grief, distress, and fear, terrible, but considered normal human reactions. On the other side, you have a clinically diagnosed psychiatric illness. To even get your foot in the door with a claim, you need medical proof of a recognized condition like PTSD. Being deeply upset, no matter how understandable, just isn't enough. Okay, so if the big problem is the fear of floodgates, what's the law's solution? Well, the courts have come up with 3 distinct categories of victim. Each category has its own unique set of rules. You can think of these as the 3 different legal pathways a claimant has to follow. And here they are. First up, you have primary victims. These are the people who were actually in the zone of physical danger themselves. Second, you have secondary victims. These are the witnesses, the people who saw it all happen but weren't in harm's way. And finally, you have the much rarer involuntary participant, someone tricked by negligence into thinking they caused the tragedy. For your exam, getting the category right is step 1. It's crucial because it tells you exactly which legal test you need to apply. Now, for primary victims, the key case is Page v. Smith. In that case, the claimant was in a minor car accident, wasn't physically hurt at all, but the shock brought back a serious pre-existing condition. The court said, look, it doesn't matter if psychiatric harm specifically was foreseeable. All that matters is that some kind of physical harm was foreseeable because he was in the middle of it. If that's the case, the defendant is on the hook for the psychiatric injury too. It's basically the Fin-Skull rule applied to mental harm, and it's a much, much lower bar for a claimant to clear. Let's move on to the most complex category, secondary victims. The law here was forged in the aftermath of the tragic Hillsborough Stadium disaster, leading to the landmark case of Alcock v. Chief Constable of South Yorkshire. This is where the courts really, and I mean really, tightened the screws to limit who could claim. To have any chance of success, a secondary victim has to jump through all 4 of these hoops, known as the Alcock control mechanisms. First, you need a close tie of love and affection with the person who is actually hurt or killed. This is assumed for parents and spouses, but everyone else has to prove it. Second, you need proximity. You have to be close in time and space to the event or its immediate aftermath. Third, you must have seen or heard the event with your own unaided senses, not just on the news later. And finally, the whole thing has to be caused by a sudden, shocking event. Let's dig into that proximity test because it is notoriously strict. What does immediate aftermath actually mean? Well, these 2 cases are your guideposts. In McLaughlin, a mother got to the hospital about an hour after a car crash and saw her family still covered in oil and dirt. The court said that was close enough. It was part of the immediate aftermath.
But in Alcock, relatives who went to a temporary mortuary 8 or 9 hours later to identify bodies were told they were too late. The court argued that the bodies had been tidied up, and that broke the direct, immediate connection to the horror of the event itself.
And that final hurdle, the sudden, shocking event, the bar is set incredibly high. This quote from the Ronnie's case says it all. A husband saw his wife after surgery, horribly swollen from an infection. He was understandably traumatized, but the court said no. Objectively, this is not legally horrifying. It's what you might expect to see when someone is gravely ill in a hospital. The law is looking for something truly exceptional and shocking, not just the tragic realities of medical emergencies.
Okay, now listen up, because for your SQE1, this is a game changer. The law for secondary victims in medical negligence cases has been completely turned on its head by a huge Supreme Court decision in 2024. If your revision materials are even a little bit old, they are now wrong. You need to know this. So here's the bottom line from the case of Paul. The Supreme Court has effectively slammed the door on most secondary victim claims in clinical negligence. They ruled that the event the claimant witnesses has to be the accident itself, like a car crash. Witnessing the consequence of earlier negligence, for example, watching a loved one have a heart attack because a doctor failed to diagnose their condition months earlier, doesn't count. The court drew a line between the negligent act, the misdiagnosis, and the horrifying event, the death, and said there's no legal proximity to the original negligence. Okay, on to our third and final category. This one's a bit more niche, but it's definitely still on the syllabus. This covers the strange situation where the defendant's carelessness puts the claimant in a position where they think they are the one who has caused someone's death or injury. The case of Dooley. A crane operator suffered a serious psychiatric injury when a rope, which his bosses had negligently provided, snapped. The load plunged down into the ship where he knew his workmates were. Now, the crucial fact is, nobody was actually hurt. But the shock of believing he had killed his friends was enough for his claim to succeed. He was an involuntary participant in the negligence.
The modern test for this was laid out in the case of Monk, and it has 2 parts. First, your belief that you were responsible has to be a reasonable one. And second, you must have had a justified feeling of being in control of what happened. Think back to Dooley. The crane operator was literally at the controls, so his belief was absolutely reasonable. He ticked both boxes.
All right, enough theory. We've covered the rules, we've looked at the cases. Let's see how you do applying all this to a couple of typical SQE-style questions.
Okay, have a read of this one. A man sees his best friend get hit by a car. He wasn't in danger himself, so he's a secondary victim. To succeed, what's the first hurdle he needs to clear?
The answer is B. He has to prove a close tie of love and affection. Why? For a best friend, that powerful emotional bond isn't just assumed by the law, unlike with a spouse or parent. He'd have to provide evidence to prove it. Okay, one more for you. A woman is nearly hit by a car. It misses her by inches. She's physically fine, but develops a serious anxiety disorder. What's her strongest claim? And the correct answer is C. Her strongest claim is as a primary victim. This is a textbook Page v. Smith situation because she was in the zone where physical injury was reasonably foreseeable. I mean, she was nearly hit. She qualifies as a primary victim. And that's a massive advantage because it means she doesn't have to worry about passing any of those incredibly strict Alcock tests. Okay, we have covered a ton of detail. Let's boil it all down into a final, simple checklist with the absolute must-know points for your exam. Seriously, this is a good moment to pause and maybe grab a screenshot of the next slide. So let's recap. Step 1, always confirm it's a recognized psychiatric illness. Step 2, figure out the victim type. If they're a primary victim, ask, were they in the zone of physical danger? If yes, the test is simply foreseeability of physical harm. If they're a secondary victim, you have to go through all 4 of the strict Alcock controls. And don't forget the huge update from the Paul case. These claims are now basically a no-go in medical negligence. Finally, for an involuntary participant, ask, was their belief that they caused a harm a reasonable one? If you can master these distinctions, you will be in great shape for the SQE. But I'll leave you with this final thought. The rules here are often called arbitrary and unfair. As our understanding of mental health evolves, the law is still stuck on this one question. How do you compensate genuine suffering without opening those dreaded floodgates? That tension isn't going away anytime soon. I hope this has been a massive help for your studies.